2026 e para a discussão do tema das plataformas digitais, os impactos dos mercados, da regulação nos mercados digitais, e o debate sobre a necessidade e a melhor forma de regulação de mercados digitais. Hoje a gente tem o Brian Scarpelli, que é pesquisador sênior da ACT, que é a The App Association, e eles publicaram um estudo recente, muito interessante, sobre os custos da regulação de IA e os impactos sobre as empresas, em particular, as empresas de menor porte. Eu vou mudar para o inglês e apresentar, então. So, good morning to all. We are very happy to start our lives this year, and we have the pleasure to have the contribution by Brian Scarpelli. Brian Scarpelli is senior researcher at ACT, the App Association, and the ACT has published recently. It's the Association for Competition and Technology, and it has recently launched the study called The Hidden Cost of AI Regulations, which analyzes the impact of AI regulations and digital regulations in Europe upon particularly smaller scale companies. So we'll have really the pleasure to hear you, Brian. Thank you very much for accepting our invitation. And as usual, we are here your contribution, and then we engaged in a more informal discussion about the study and perspectives, particularly to debate the context of regulation of digital markets or regulation of AI in Brazil. So I leave you the floor for presenting your work, and then we start a discussion. Bianca Molicone has joined now. Hi, Bianca.
Hi, Juliano. Hi, Brian.
Thank you.
So thank you very much, Brian, and the floor is yours.
Thank you. Thank you so much, Juliano, Cesar, Bianca, and everybody else who's here. Really appreciate being able to. It's always a privilege to be able to speak with you all, and with an audience that's so actively shaping the next chapter of what the digital economy in Brazil and elsewhere will look like. So, thank you again. Yes, as you just heard, my name is Brian Scarpelli. I'm with the Association for Competitive Technology, or ACT. I happen to be based or headquartered, I guess, located in Washington, D.C. in the United States. But much of the work that I do and our association does, which I can describe in a moment to you, is really at the intersection of artificial intelligence and emerging technology regulation and competition policy. So today I'm aiming to share some research that we think is genuinely important for any.
Your mic is on. Could you turn off? There
we go. Okay, great. Thanks. I'm sorry. I think I was just saying, we think that this research is relevant for anyone thinking about researching, working on shaping AI governance and digital economy governance, including in Brazil. So here, let me make sure I can advance these slides. Here we go. So just a brief background on who we are, so that anyone listening to this understands where we're coming from. The Association for Competitive Technology, we're a global trade association for any small and medium-sized technology developer that's, either in the writ large. So there are members of our association who are developing tech in consumer contexts. There are members of ours who are developing technology in enterprise or business contexts, and sometimes both. And it's a variety, a huge diversity of business models and approaches. There are open source developers. There are physical Internet of Things device developers who are making also developing the software around them. And there's still a very strong portion of our membership that is developing, that are what you might consider an app developer who's relying on a publicly accessible digital platform or app store that many of us use in our own lives for all kinds of things, and lots of other interesting flavors of technology development. So it's a whole bunch of entrepreneurs, innovators, and independent developers that are operating within the global ecosystem, digital economy, or digital ecosystem across any industry. And these companies are building the tools hospitals use, the apps on the phone, enterprise software for small businesses, and on. One figure that maybe is worth noting, grounds us a lot, is more than 83% of the companies that are in our membership, they exist outside of I suppose what people might have a stereotype of like a traditional tech hub like Silicon Valley or something like that. With coding skills, with an internet connection, a developer can succeed from anywhere, including in Brazil, and mobile and cloud capabilities combined together. They're driving roughly what we estimate to be 28 trillion US, or 146 trillion reais worth of global commerce annually. And so that's the ecosystem that our members are part of, and that is why we are researching in this area and advocating in this area. So our perspective is always that of the small innovator, the startup, the micro, small, or medium-sized entity, and that's, just thought I'd give a brief background there about who we are and where we're coming from. Okay, so I can tell you about how this research was done, because the methodology always matters too. So we commissioned 2 independent studies. They're conducted by a firm called Technometrica Market Intelligence. They're a well-respected polling and market research firm. And we ran 2 separate surveys, one targeting companies in the EU, in the EU and in member states, and another and the United Kingdom, and then another survey targeting companies in the United States. So combined, we surveyed more than 1,000 technology MSME enterprises in the technology space. And these firms range from solo founders to micro firms with fewer than 10 employees, all the way up to a few mid-sized companies. And I should also note, we surveyed, 2 distinct groups within that sample. First, there were AI users, companies that have adopted AI tools, integrated them into their operations, their workflows, their products, and also AI developers, companies that are actually building AI models and applications or services. And these are they're meaningfully different perspectives, and we asked different questions of each group. So the survey was conducted in 2024 and 2025. So this is pretty current, real what we think is current real world data, not hypotheticals or projections or theoretical models. Make sure I go to the next slide. Here we go. So before going deeper, I thought I would give some of the headline findings. These are maybe three key things that hopefully you'll walk away with from, if nothing else. At least that they're ones that jump out to me. The first is that delays cost real money. EU and UK tech firms are losing on average somewhere between 584,000 to 2 million reais per year per firm from regulatory delays alone. And contrast that with US firms that are achieving higher cost savings from AI than their European counterparts, at 10.7 median cost reduction versus 8.9% in Europe. And that gap compounds over time. Second, the EU and the UK are in our, I think this demonstrates, falling behind in AI adoption. Only half of European startups are actively using AI. In the United States, it's nearly 2/3. And when it comes to fully integrating AI into workflows, that is, embedding it, the gap is even wider, 45% in the US versus only 32% in Europe. And third, that regulation does appear to be the driver here. There isn't a gap caused by lack of interest or lack of talent that we have generally seen or that we're identifying here in what we've surveyed, but it really does come down to the government's role here and the form and nature of the regulatory interventions that are occurring. 6 in 10 EU and UK tech firms reported delayed access to frontier AI models because of regulation. Nearly 60% of European developers say regulation has delayed their own product launches, and more than a third have been forced to strip out or downgrade features just to comply with regulations. So I hope that you all agree those are some striking numbers, and we can look at some of these dimensions in further detail here. This slide is meant to capture the adoption gap visually. So as I mentioned, just elaborating on maybe one of the major points that I just raised a moment ago, but in the EU and UK, 50% of tech MSMEs are actively using AI. That sounds reasonable, but when you compare it to nearly 65% in the United States, that's a 12-point percentage gap and in basic adoption amongst companies that are by definition technology companies. And the integration gap is even starker. When we asked how deeply AI has been embedded into core workflows, not just used occasionally, but built into how a business operates, only 32% of EU and UK firms indicated that they have done that fully, whereas in the United States, it's 45%. So it matters for business outcomes. If 83% of US firms say AI is important to their business versus 73% in the EU and UK. And so these aren't large gaps on their own, but they're directionally consistent. If you will, and they're driven not by a lack of enthusiasm for AI, but by structural barriers to assessing and deploying it. And and I don't think that I should just to put out there too, as in our view, and the data doesn't reflect this, in our anecdotal in our discussions, companies don't reflect it. It's not that firms are smarter or something like that in one place or another, or more innovative. They're simply across around the world, they're simply operating in an environment where the rules allow them to move faster in one place than another. Okay, slide 6. I'm on slide 6. Great. This is, this I think I hope is an important slide, and that column on the left I hope is compelling as you look at it. But 6 in 10 EU and UK tech firms face delayed access to frontier AI models. This isn't about firms choosing not to use the latest tools. It's about them being unable to access those tools because of regulatory uncertainty and compliance requirements, or because the platform providers that are building those models have chosen not to release them fully, in this case in the EU, while they're pending regulatory approval. 58% of developers told us that regulation has delayed their own product launches. Nearly 1 in 3 has to strip out features or downgrade functionality to get their product to market in a compliant state. And there's downstream effects. Half report slower innovation overall. 45% face higher operational costs. Nearly 30% have lost clients directly attributable to these delays. So if you look at the right column, which is depicting the US picture, 44% of US developers do report launch delays tied to regulation, but most describe them as moderate, and 54% say they face no delays at all. So there's we didn't find any structural barriers to accessing frontier models in the US. So I hope that this illustrates, something we concluded from this research, which is that in the US, the regulation is more of a speed bump, if you will. In the EU and the UK, it's more of a barrier approaching a break. Okay, here we go. This is just a quote from one of our EU member companies. We feature it. I thought I'd feature it here because I think his words, Mitchell, capture something important. He's talking about, in this case, he's talking about Apple Intelligence and iPhone mirroring, which are specific AI features that Apple released in the United States and other markets, but that are restricted and or unavailable in the EU due to the Digital Markets Act. And so it's just illustrating, hopefully to you all, and reinforcing that this isn't hypothetical. This is a specific company, a real entrepreneur, talking about how regulation is preventing him from accessing tools that his American competitors can use freely. And he makes the point that this affects competition directly, competitiveness directly, not just for his firm, but for the region as a whole. So when regulation creates unequal access to technology tools at the frontier, it creates unequal competitive footing, and that's happening today. Let's see, quantifying the cost of delay. So just based on the research, hopefully it helps to put some figures, assign some figures to this, make it as real as possible, because what often gets lost in regulatory debates is that these aren't just policy abstracts. They're real financial impacts, and in this case, I think losses for real companies. We calculated using 2 methodologies, which you can read all about in the full report, but for the slides here, I made sure to convert all of our figures to reais at approximate current rates. And the first metric is annual revenue at risk, capturing lost business directly for all EU and UK tech MSMEs. The average is 162,000 to 325,000 reais per firm per year in lost revenue. And for firms that are directly affected by AI-related client losses, which is about 29% of the sample, that number jumps to 561,000 to 1.13 million. The second metric is foregone savings. This is the cost savings from AI that firms never realized because the model or feature that they needed was delayed. A 3-month delay costs an AI firm approximately 409,000 reais in savings they won't capture. Stretch that to a 12-month delay, and the foregone savings rise to 1.64 million. So when you combine revenue at risk and foregone savings, the total annual impact across all EU and UK tech MSMEs is 571,000 to 1.97 million reais per firm on average, rising to 975,000 to 2.77 million for directly affected firms. So if you multiply those numbers across tens of thousands of tech MSMEs in Europe, you're talking about an enormous cost on aggregate. Real wealth that's not being created, real jobs not being supported, that are a direct consequence of the EU's regulatory design choices, largely. Okay, I think I'm on the right slide here. So this is a comparison table that that we're aiming to depict the divergence across 6 key metrics side by side. I can highlight a couple here. Cost savings realized. So 85% of EU and UK firms report cost savings from AI, and that sounds positive until you compare it to 91% in the US, and the median reduction 8.9% in Europe versus 10.7% in the US. That's nearly a 2 percentage point gap in efficiency gains from the same exact technology. As far as another one angle to highlight, I think is maybe investment intentions. 89% of EU and UK tech firms plan to increase AI investment, and that's strong. That's positive. But 94% of US firms plan to, and American firms are much more likely to make significant increases rather than modest ones. So among MSME firms specifically, or micro firms really specifically, the smallest companies, the ones that struggle with compliance cost the most, just because they don't have the resources, or and I mean more than financial, but also in-house counsel and things like that. 27% of U.S. micro firms plan significant AI investment increases, compared to only 13% of EU and UK micro firms. So again, this divergence, we think, is consistent, it's directional, and it's growing. And the US, it appears that US firms are embedding AI faster, aiming for higher value applications, and reinvesting more aggressively, and the gap is not closing. So we think it's worth understanding the specific regulatory frameworks that are producing these effects, because this directly informs the lessons that anyone else can draw from this. And personally, and I know others at ACT feel this way too. I think that Brazil writ large, the researchers, the advocates, the policymakers in government, if we think of all of that whole community as policymakers, are an incredible opportunity where they can observe deployments in the EU and compare and contrast with other important jurisdictions, and conclude what's working and what isn't. The EU AI Act, which you see here listed at the top, is the world's first comprehensive AI law. Takes an ex-ante approach, meaning it's imposing requirements before products reach the market based on anticipated risk classifications, and there's a compliance burden for conformity assessments and technical documentation and audit requirements, and they're substantial, and they fall disproportionately on small firms, which is probably not a surprise to anyone. The Digital Markets Act, which has been around longer than the AI Act, regulates designated platform gatekeepers. I'm going to put in quotes around gatekeepers, because that's an important term under that law and a designation. But the practical effect is that these gatekeepers have and may continue to restrict or delay AI-powered features in the EU, because embedding them raises DMA compliance risks. This is what Mitchell, the quote that I earlier displayed, was talking about when he was saying he can't access, in his case, Apple Intelligence. And then what's been around even longer for the EU is the GDPR, which I'm sure everyone has probably heard of. It's a relatively aged or older law at this point, but that too creates friction for AI training and deployment anywhere personal data is involved, which is almost anywhere in everywhere, really, in modern AI. In the UK, the DMCCA mirrors several DMA concerns. It is in its operation appears to be provide far more flexibility to platforms designated as having significant market status. But the UK has a GDPR that also parallels EU restrictions. The common thread across all of these is that they're ex-ante frameworks. They regulate before the outcomes are known based on anticipated harms, and contrast that with the current approach that the US has, which by contrast has largely relied on ex-post frameworks that hold actors accountable for actual demonstrated harms. And the data in our surveys, I think, makes a strong empirical case that the ex-post approach produces better outcomes for innovation. I just to talk a little bit more about why we think this matters and it speaks directly to Brazil and provides some good context is that extremely important markets, and namely Brazil, are currently designing their own AI governance frameworks in several ways. So we're hoping to emphasize that proportionality matters. Firms that bear the heaviest burden under blanket ex ante rules are usually the firms that are developing that economies need to cultivate, that they want to develop, that is. And the MSMEs that can't hire compliance departments, they're deeply affected by this. Rules designed with large enterprises in mind have the tendency to squeeze out or create a broader moat for smaller innovators who are driving, in many cases, the majority of job creation and competition. Also, that timing is a competitive advantage. If you're domestic, if firms in Brazil have rapid, unconstrained access to frontier AI models, then they compound their advantage over time. And regulatory delays aren't just like a one-time convenience. I think they set firms back at a moment when the pace of AI improvement means missing 6 months or more, and that can mean missing an entire technology generation. The Brussels effect, it's a real thing, and has been for some time. Just to emphasize that, when the European Union enacts these sweeping early stage intervention regulations that are effectively interventions into emerging and developing markets, it's shaping global norms, not even necessarily through law, but through market pressure. And companies building for global markets, they often will find themselves having to design to EU standards because it's easier than maintaining separate versions elsewhere. So if Brazil and other economies adopt EU-style ex-ante frameworks, they may inherit the same bottlenecks and the same costs without the same single market benefits that motivated Europe's approach. Our recommendation, and we make this globally, is to prioritize regulatory sandboxes and test beds that allow experimentation under supervision, where there's identified high risk before full rules are locked in, and policymakers learn more from observing real deployments than from moving forward with systemic policy changes based on theoretical or hypothetical risks. We're hoping that we can just surface these and make the case that the evidence, a lot of good evidence for the policymaking community in Brazil is available now, and there's a great opportunity to design AI governance that learns from what Europe got wrong and right, and captures what the U.S. approach has gotten wrong and right. Okay. So our formal recommendations are pretty much grounded in this survey. First, we just want to ensure, we all, I think, want to ensure timely access to frontier AI models for MSMEs. So, we should build clear timelines into any regulatory review, create safe harbors or expedited pathways for small firms. And we don't want to let regulatory uncertainty become a de facto ban on deploying new tools. The second, we want to scale the burden and the risk and to the risk and the capacity. So start with 8 employees, for example, should not face the same compliance requirements as a company with 50,000. Proportionality is the difference between regulation that protects consumers and regulation that protects incumbents. We also want to let companies experiment in a supervised environment before full requirements, are applied. So hopefully the real world data can be used to calibrate these rules. And this is a particularly powerful dynamic in rapidly evolving domains like AI. Last, we don't want to see AI regulation treated as a standalone exercise. I think placing startups and MSMEs at the center of a digital strategy, not on the margin, is important. And I think it's fair to say objectively that that the European experience shows what happens when you don't consider the interests of startups and MSMEs at the core of what you're doing, while at the same time trying to drive their growth. So I'll close with this. The research is in our opinion, and I hope that our data is insightful. I think the European experience demonstrates what can happen when regulation precedes innovation at scale. Firms lose access to tools, they fall behind in adoption, and they bear real costs, quantifiable financial losses. So I think we have the benefit. We all have the benefit of being able to contrast that with at least one other major market, the United States, where firms are demonstrably operating in a more flexible environment, moving faster, realizing greater cost savings, and embedding AI more deeply. So, just would maybe kind of close by saying, this certainly isn't a hypothetical. I think for Brazil, an incredibly dynamic digital economy and community of technology developers in Brazil, and I think that there's a choice between ex ante control and ex post accountability that has measurable, documented consequences. The difference is really not whether to regulate AI. Of course, there's a legitimate role for government, and I do want to emphasize that. But the question is whether the regulatory design accelerates Brazil's capacity to benefit from AI or holds it back. So thank you, and welcome the discussion. I hope I didn't go on
No,
too
still
long.
Still have time. It was really excellent, Brian. Well, I have 2 questions. First of them, just a clarification. As I have noticed in your presentation, companies are referring, actually the studies refers to the AI Act and the costs of the AI Act, but the companies are somehow referring to digital regulation in general in Europe.
Mm-hmm.
As you said, the DMA is already in force for a greater time, and there are also other studies that indicate that the DMA is actually provokes a delay in launches of products and innovations or new additions to products that are already in the market. So just a clarification, actually, the research was focused on AI, but it also bring information about the impacts of European regulation in general. Is that right?
Yeah, that is correct. I think and I did probably talk a good deal there, maybe about the AI Act. It is maybe the most recent version of one of these ex ante type interventions into emerging markets, but the DMA also, I agree, has an effect, and we actually, gosh, I wonder if there might be some further research and writing that we have done about the DMA specifically that I'd be happy to share. But I think to dig in very briefly on the DMA, while it does target it's that I think I made some comments about a focus on the largest household name, like most recognizable names, largest companies, without considering the impact on the smaller businesses, is quite a damaging. I think is rather inherently damaging, and the DMA I think is another example of that. What I think is lost by the
let me jump in. There is also a recent study by CIA.
Yeah.
That actually they try to investigate the dimensions of the impact on the tech companies of the different regulations, and also actually it finds out that the DMA has a greater impact on compliance costs than the AI Act. Probably because actually not all products usually they in the digital market usually they deploy AI systems, but not all of them.
Right. I've seen some of that. That's very important work that CCIA has done, and I agree, and I think well, I do think that the smaller that the MSME community is sadly on the wrong side of the moat that the DMA has created for a lot of the reasons that I was talking about here, but also I think that are illustrated by that CCI report. The smaller entities who develop apps for digital platform distribution pathways or app stores. There's, if you want to, I guess you could call it like, it's like the sea anemone and the clownfish or something like that. There's a symbiotic relationship there. The platforms need developers to operate on them and to generate commerce and to make the platform relevant. And so they work to attract the developers by improving their features, and the developers rely on the platforms to ensure that these are actually trusted pathways, and through means such as enforcing terms of service to ensure that privacy terms are adhered to, through providing at a platform level system-wide cybersecurity risk mitigation and patching, and by resolving, by efficiently and quickly resolving intellectual property disputes that may arise, a branding dispute between two briefs. So these an intervention like the DMA, in a quest to enhance interoperability, is maybe the word that maybe dominates the motivation for it. Effectively is doing so, at least in the case of the DMA, by putting handcuffs on the platforms to provide some of those key functionalities. Mm-hmm. And there are other, by the way, there's many hours of very interesting discussion that could be had about different iterations of platform regulation from other jurisdictions, such as Japan, that appear, and even relatively the UK, that through its DMCC Act, that are operating in a far more reasonable and flexible way. it's a great point that you raised. Hopefully,
I'm bringing DMA because actually, if you see, the AI Act is not driven to enhance competition or to protect competition. It's there's another drive for protecting human rights, and all regulation that is not driven to competition may have an effect of bringing costs to companies, and usually these bring higher costs or higher difficulties and challenges to entrants rather than to incumbents. So we somehow expect that, but of course, the impact cannot be such that it hinders competition policy in a degree that is that brings imbalance to the market. But the DMA is driven to protect and enhance competition. So it's quite problematic when you see that the effects of compliance are bringing such impacts that hinders in a stronger way the activity of entrants, and not only on digital markets. As you say, you are bringing effects on smaller scale companies in general, and the cost of not accessing innovation. And well, my second question, actually, we have launched recently, last year, we have launched a study on the impacts of actually, it was about competition in AI markets, and we have raised some question marks on the joint statement by the European Commission and the FTC and the Competition Markets Authority in England on the idea that the AI markets, the concern is that AI markets will be at the face of the AI markets will be similar to the digital markets, with a domination of bigger companies, in particular of the big techs. We raised some question marks because this statement is based on the studies that make strong but questionable analogies between the characteristics of digital markets and the characteristics of AI markets. And we have also used and based much of our discussion on the dynamics of AI markets, as it is shown by interesting data which was published last year by Sensor Tower, where they measure the activities on downloading and subscriptions of apps in application store, and it is interesting to see regarding AI markets that we have usually popularity does not translate immediately. Popularity of AI apps does not translate immediately into revenue. And US companies usually they are leading on revenues, on subscriptions. Of course, because they were pioneering this market, and so they have an advantage on that. But when it comes to downloading, the US companies are in fourth place. So largely, the first place is dominated by Asian companies and Asian apps. Then come European apps, a little lower, then Latin American apps, and then US apps. This was a really interesting data for me, because it shows a real dynamic of competition. So do you believe that regulation would bring a balance to that and maybe favor companies that are already having revenue? Because, of course, if you have cost of compliance, it's important to have revenue to invest on compliance. And usually this will lower the amount of money that is driven for innovation and for investments in the product.
Yeah, that's fascinating frame up that you raise. I would more regulate would new regulation alter this dynamic? Potentially. I still think that I'm not sure I can give you the a Teflon reason for why there's the different maybe rankings, I guess you could say, as far as like subscription revenue versus downloads. That is a fascinating dynamic that I should look into more. But I do. I think that for me, I guess where I end up is the same maybe principle kind of. I still find myself kind of centering back to the idea that a lighter touch will on net reduce barriers to entry. A lighter regulatory touch will reduce barriers to entry that would make it easier for some of these newer, smaller entities to get into any particular vertical or market and I'm just sitting here thinking about
Yeah, no, it's difficult to think about the consequences. And actually, what we are saying in this study, that there's a lot of presumptions by the competition authorities that are not really checking out the real effects and dynamics of the AI markets, which are quite interesting, as you see in this data. I will later send you this report. It is in English, actually. And there are very interesting aspects that if you look carefully into AI markets, the dynamic is quite different from digital markets. And that's why we believe in the Institute that it's quite disrupting for the digital markets.
Mm-hmm.
And but actually, these we have to take care and be careful on regulation, particularly because the data about these markets even surprise us. So the risk of error in regulation increases, and Europe has been pioneered in the regulation of digital market. They give the first step, and and this may be hindering, as you say. So these perspectives are complementary, because it says that in this field within such a dynamic of innovation, it's probably better to be more careful and adopting tools to protect competition gradually. Of course, there are important points that are raised in the debate about the dynamics of competition in digital markets, the domination of big companies. But I think that the problem is to come with a package of regulation where you cannot control or foresee side effects when you have this dynamic. So we particularly I cannot talk for Cesar and Bianca, but myself, I usually believe in an approach that is more careful by adopting gradually tools based on evidence that this will really be effective on protecting competition, because each of these tools will have side effects. But when you bring a package of changes or ex-ante regulation, you cannot foresee the impact that it will add up by each of the constraints, add up in bringing maybe some undesirable effects on the development of the economy. So we are in Brazil. We are particularly within this discussion. We are discussing one draft bill on AI and another one on protecting competition in digital markets.
Right. Yeah. You know, I just, if to just, you know, strongly agree with your framing there. I guess I tend to, I find myself looking at, and it's important too. I'm glad that you know, that we've raised, and I know I did this maybe only briefly, but previous early market interventions by the EU into markets as they were just forming and developing. And I think that the DMA is one that has played further out just because it's older, but it is, I think I'm only starting to observe some corners of EU policymakers, like some small groups of members of European Parliament, primarily, you know, that are reflecting on the fact that, you know, that the EU is, as part of its thought process, you know, as a theme, is thinking that early interventions, putting ex ante rules in place that are largely one size fits all for emerging markets that are not, especially with the AI Act, not even close to, no one knows how those markets truly are going to develop, but these early intervention rules are going to somehow spark this wave of investment and innovation from particularly the MSME community, and then they're perplexed and confused and upset when it doesn't happen. And I think some policymakers, even within the European policymaking process, are starting to say, we're doing the same thing many times and expecting different results.
Brian, that's in this line, I would like to ask you, recently, we saw that Europe launched digital omnibus that aims to simplify or coordinate its multiple digital regulations, such as AI Act, DMA, DSA, GDPR. And I think that this object is really to try to simplify its regulatory framework in digital markets to reduce the friction and improve competitiveness. And the concern that we see in these rules taken together may create really a cumulative burden, especially for SMEs. And talking about lessons for Brazil, Brazil is currently debating the AI regulation. And as you said, in emerging markets where we see that digital transformations is still accelerating, the opportunity costs of delay, I think it's even higher than in developed countries. So do you see evidence that regulatory stacking like AI plus data protection plus platform regulation, as your studies shows, that creates cumulative friction that policymakers often underestimate? So if Brazil adopts a framework closer to the Europe model, what do you think are the safeguards that could mitigate these competitiveness losses, like sandboxes or phased obligations, safe harbors? And conversely, if Brazil prioritizes competitiveness, what minimum safeguards do you think that are essential to really maintain trust without discouraging innovation?
Great question. Thank you. Well, first, I would say that omnibus exercise that the European Union is currently going through is extremely important, and we're engaged. We're actually engaged on that in advocacy on that, because there is a very stark need, I think, across a range of different regulations and directives, and where even in some cases where there's not harmonization across different member states to simplify their regulatory regime writ large, and the fact that they're undertaking this exercise is a recognition by them that there is a stark need for that. And going back to like the Draghi report and things like that, I think that this is recognized. It's just one hopes that this actually translates to meaningful reform. I think the way you just summarized kind of the cumulative friction is very well put. I certainly would agree with that. And there is kind of this choice here, a fork in the road, maybe. I think if Brazil does elect to follow the lead of the European Union, I think that. Well, first off, as you can tell, I think that would be unfortunate, but there are even within that, there are changes. There are that Brazilian policymakers could make to that construct when they enact it for Brazil that will help preserve the ability for MSMEs to, for example, to scale up more easily. I do think safe harbors and are a great example of that. And there, something else too that may be worth noting if we're talking about safe harbors is that there are a great many there's a great deal of actually even competition within the standard setting space. And I'm raising that because standards bodies, international standards bodies like IEEE and others are developing AI risk management. ISO is another one, ISO, are developing risk management frameworks for AI. And, and those can be certified to, they can be self-attested to, they could be certified to after, by a trusted third party entity, for example. Could that be tied to a safe harbor? Would that provide enough of an assurance that, especially for lower risk AI use cases, that consumer privacy and safety is being ensured? I would argue that that's a very workable solution to. As well, I think I raised before too, the idea of regulatory sandboxes are also really important. If the other path is taken, I guess, that is, if Brazil were to kind of roundly reject the EU's AI Act, like a similar approach, I would argue that. That's an advisable role because Brazil already has, I think, robust technology neutral consumer protection and competition regulations in place that I believe could be leveraged to address demonstrated harms quite rapidly. And if that route is gone, I mean, it would be an interesting exercise to see a comprehensive evaluation done of what existing laws and regulations Brazil has in place that can address, the leading potential risks related to AI deployments, and whether those risks are actually AI dependent. I do wonder about that. Is AI in many cases, AI is like a supercharger, or like turning a hammer into a power drill or something like that, at least for me. So is the mere fact that AI is being used actually that unique? That's a fair question to ask. I think that probably, and if the answer is no, which I think the majority of the time, I think that the answer would probably be no, then there's either then probably, existing competition and consumer protection laws should be adequate, should be able to, to be leveraged to protect against those harms.
And I think that we're seeing that AI is regulation is becoming a tool of industrial policy. We are seeing that regulatory design really influences which jurisdictions are winning the AI race. So I think that paradoxically, over-regulation can even reduce consumer protection in the long run, because it can slow innovation and productivity gains. Yeah. So if you are advising Brazilian lawmakers today, what a single principle should guide AI regulation to balance safety and competitiveness, in your opinion? And then I pass to Cesar for a question.
Great. Okay, a single like kind of principle or theme. That's a great question. I think it would be I guess I might have a theme and a principle. I think maybe the theme would just be that I think the theme would probably be to recognize that there is a shared responsibility throughout an entire AI value chain for provide for efficacy and quality and safety, and that responsibility I think should be based on known and intended uses and the ability to do something about them. That's a very high level, but I do, I think a tension that I see come up across different jurisdictions is is attempts by policymakers. They'll look at say there are 10 actors in an AI value chain. They'll look at the deployer, like at the bottom, and they'll put all the liability on that deployer in the expectation that they will contract away up the value chain the risk. And that sounds like a great solution on paper, but it always translates in the real world to legal risks that lead to in-house counsel saying no, don't do that. And it slows deployment. So it's not, so that, I don't know, that's something of a theme. I think, a shared responsibility. I think maybe just as a principle, that truly reflect that having a construct in place that permits the scaling of what actions are going to be required to be taken to mitigate a demonstrated harm, that those can scale to the harms presented is really important. And that's maybe a contrast with I would argue, even though the EU AI Act does have categorizations of AI as high, medium, and low risk and stuff, that those are very broad brushes that they're painting with. And by the way, in the same breath as them categorizing risk of AI, they also have taken entire use cases and banned them outright. And that's they have legitimate concerns in maybe making those bans, but we can't know whether banning a use case outright, rather than permitting, even if it's quite high risk, rather than permitting some deployment with appropriate risk mitigation measures, might have on net incredible societal benefit. And we'll never know that for some of the use cases. And the word of these bans, the wording of these bans also really matters. I know, again, their intent is it's well intended, but how would these things be applied, and what use cases will we never see come from some European company? So scaling, yeah.
Brian, I think that you emphasized enough the question for the challenge of introducing EU-like regulations for AI and for gatekeeping, like DMA. How can they cause damage to innovation, mainly by small companies? That's an opposite effect that we are expecting when gatekeeping regulation were introduced. But you also quote GDPR regulation as an important source of heightening innovation. And in this case, because in the other two cases, gatekeeping and AI, we still don't have a regulation, so we can choose. Brazil can choose. But in the case of GDPR, we already have a regulation working, and in Brazil, it's not pretty sure what will be the relationship with AI. I'm not aware of cases of AI in GDPR, and I don't know if whether Bianca and Juliano are aware of cases in Brazil, but and the point is we already have a legislation working in Brazil, and when you compare the US and the EU, in this case, the US doesn't have a federal regulation for this, but it have multiple regulations in states, different regulations in the states. And perhaps it is worse than you have a single federal regulation. And in this case, perhaps the United States is worse than the EUA, than the European Union, because perhaps it's not that clear what is the rule. So I'd like you to tell me what's the wave of GDPR in this bundle of regulations in heightening in blocking innovation for small companies, for small startups, and in your case the app industry, and whether the United States, the model of the United States with a lot of different regulations state by state, perhaps it's even worse than you have a single federal regulation for this.
Very good question. Yeah, I think I may not be answering each of these kind of as I was each of these maybe sub questions as I was thinking about them as you were posing them in the order you did. But I guess I think it'd be fair to say that if we're assessing or weighing responsibility across GDPR, DMA, and EU AI Act in driving the responses that we got in the survey, that probably the GDPR would play maybe the lowest, have the least responsibility or weight. I mean, you raise a extremely important point about it too. In the context of Brazil, there is the LGPD. Which is very, very much very, very similar, and it's true. It remains. I think maybe it remains to be seen whether how the intersection of AI technologies, interfaces is probably the right word with comprehensive data privacy laws. I don't think I don't mean to put forward to you all that the U.S. approach, which, as you accurately note, there is no comprehensive federal privacy law for the United States, and the result of that for a typical small business that's operating in numerous U.S. states is that they will find themselves having to comply. If they're operating in 50 states, they potentially are complying with 50 different privacy regimes. And that's unfortunate. That is not good. I don't think that is preferable to having a single set of requirements. Because I think for companies that have navigated, for companies that we talk with, for MSMEs that we talk with, into like practical their reaction to having to navigate 25 or 30 or more different privacy laws across different states, they do eventually almost stop caring about what they have to do. They just want to know what in each of the states and the severity of the steps that they have to take relative to the risk being presented by what the use cases that they're enabling. And they just want to know, they would just like to have to do one thing one time, and they almost stop caring about what it is that they have to do. And that's maybe just being worn down or something like that. So, you know, for our part, we are trying to get a federal privacy law passed in the United States. The issue, to make a long story short, is that federal, you know, that there would be a need for a federal law in the U.S. to preempt, in some aspects, what states could do, and there's, from some corners of you know, of the spectrum, there's resistance to that fact. But I think that is a fact that will have to be overcome if there will ever be a federal U.S. privacy law. So it's not ideal. I think, I mean, at the same time, I don't necessarily have the greatest solution here, because so like that, I mean, that's a stark assessment that I can just give of the US situation. At the same time, comprehensive privacy laws like the GDPR, like LGPD, do have compliance costs. There's no doubt about that. You know, and I think that they were included in our survey because they are maybe one of the first interventions from the EU that into truly a digital economy, into the digital economy, I'll just say, that had a deep compliance impact and had a global impact, you know, that saw similar laws adopted in many other jurisdictions. So, so in summary, it probably has lower weight as far as the fracturing that we're elaborating on through the data points in our study than the DMA and the EU AI Act, but it has some. But you know, at the same time, you know, we're not pretending that having no privacy law in place and having disparate requirements across sub jurisdictions in a major market is optimal. It certainly is not. So, you know, and so I maybe just to end my answer on maybe a more positive note is I do think that a law like the LGPD could be a great example of an existing construct that enables dealing with privacy concerns, whether they're driven by an AI use case or whether they're not driven by an AI use case. It's a flexible enough regime, hopefully, to do that. Much like I was mentioning, kind of, you know, briefly that existing consumer protection and competition laws could, you know, should as a first step, you know, I think it's worth looking at whether existing laws can address these risks that are being harms or risks that are being raised by a particular AI use case before a brand new AI law is dropped on top of the existing framework. So the LGPD, I think, in Brazil could be an important part of that.
Cesar, do you have any complementation? So, Brian, thank you very much. We are already at 10:30 a.m. So it was really rich, your presentation, and insightful, our conversation. It was really a pleasure to have you here to debate.
Thank you.
Competition.
I really appreciate it.
So, Bianca,
And we would like to sincerely thank you, everyone, for joining us today for another webinar of Legal Wing's Digital Markets Hub. And it was a pleasure to have Brian with us and all of you to this great debate and to benefit from the exchange of knowledge and experience that enrich our discussions. Before we close, we would like to remind you all that the Digital Markets Hub has a dedicated page on the Legal Wings Institute website, and there you will find a comprehensive repository of content related to the topics we addressed today, including recordings of our previous live sessions, recommended biographies or bibliographies, and other materials that may be of great interest to researchers, to students, to decision makers, policymakers. And so we thank you all once again for participating with us, and we look forward to seeing you at our upcoming events. Great weekend for everybody. Thank you, Brian. It was a great pleasure. Bye-bye, everyone.